In this video, we'll be exploring intestacy. Remember, intestacy is what happens when the decedent does not leave a valid will, or the will doesn't dispose of all of the probate property. So instead, this property will be disposed of by the probate court based on the intestate scheme in that state. The intestate scheme is just a fancy way of referring to the state's default rules on who gets the deceased's property. It may help you remember these rules if you understand the philosophy behind most intestate schemes. You see, intestate schemes were meant to mimic what a typical decedent would have wanted. It is the presumed intent of the decedent. So generally speaking, these intestate schemes help the court determine two primary issues. The first is who gets the decedent's property. And the second is how much of the decedent's property does that person get? First, we're going to talk about who. States differ in how they design their intestate schemes, but most of them follow the same basic order of who takes. In most states, the surviving spouse is the first taker. And I abbreviate surviving spouse throughout by using SS. Well, how does one qualify as a surviving spouse? States typically require a valid or a legal marriage in order to recognize somebody as a surviving spouse. To be a surviving spouse, the individual also has to survive the decedent. What does survive mean? Well, at common law, which I abbreviate CL, at common law, all that was needed to prove survival was a preponderance of evidence. A preponderance of evidence that the surviving spouse lived even 1 millisecond longer than the decedent. The UPC approach uses the 120-hour rule. And this rule says that there must be clear and convincing evidence that the surviving spouse survived the decedent by at least 120 hours, which is 5 days. If the surviving spouse doesn't meet the appropriate test, so they're not technically surviving, then they are treated as having predeceased, which means died before the decedent. So the surviving spouse typically is the first member of the family to take. And we'll talk a little bit later about how much the surviving spouse gets to take from the estate. The next group that is in line to take are the decedent's issue. Issue means descendants. So this could be children, grandchildren, great-grandchildren, and on down the line. How does one qualify as an issue? Well, to qualify as an issue, the person must have a parent-child relationship with the decedent. And this can be established in a number of different ways. If the child is born during a marriage, then it is assumed that the child is the product of the marriage. So if the child is born during the marriage, it is assumed that the child is the product of that marriage. If a child is born outside of a marriage, then genetic evidence can be used to establish paternity or maternity, or evidence can be admitted to show that the decedent held that child out as their own. So, evidence of the relationship would suffice. A child can also qualify as an issue through a legal adoption. In most states, a legal adoption acts to sever the relationship of the child to their biological parents, so that child typically cannot take under the biological parents, but they do take under their adopted parents. Finally, a child can qualify as an issue through the doctrine of equitable adoption. Equitable adoption. Equitable adoptions are usually found when there's no legal adoption because of a technicality, but the adoptive parents did want to adopt the child. All right, so let's say that there is a decedent who doesn't have a surviving spouse, and that decedent doesn't have any surviving issue. Then who does the property go to? The property would go to the decedent's parents. If the decedent doesn't have living parents, then the property would pass to the issue of the decedent's parents. So this would be the brother and sisters of the decedent and nieces and nephews of the decedent. If there are no issue of the decedent's parents, then it would go to the grandparents of the decedent or the issue of the grandparents. And if there's no grandparents, it would just go to the next of kin, the next closest relative. And if this person has no relatives, then the property goes to the state. Now, it's important to note that a person that is a member of one of these groups can still be barred from taking during intestacy, particularly under the Slayer statute, right? So most states have a Slayer statute, and Slayer statutes, they prohibit a taker from taking under an intestacy scheme if they killed the decedent. So if the taker intentionally and feloniously killed the decedent, then they cannot take. They're treated as if they predeceased the decedent. Okay, so far we have talked about the order in which property gets distributed in probate. Now we're going to shift to talking about how shares are calculated when property passes through intestacy. Now we're going to use the UPC approach that is summarized in your textbook. You can find it on page 69. It can be a little complicated at first glance, so let's walk through it. A couple of words on the abbreviations that your textbook author uses. So your textbook author uses S to represent surviving spouse. You may recall I use SS. And your textbook author uses capital D to refer to descendants or issue. Now, this may be a little bit confusing to you because I have used D. This is Dr. El-Sabawi's notation in purple. I've used D to mean decedent, right? And the decedent is the person who has passed away. So as to not confuse these two, I usually use lowercase d to represent descendants or issue. So let's just go ahead and change these to lowercase d so we don't get confused. Okay. It's always a good idea to diagram out the relationships. So in this scenario, we have the decedent, and the decedent has a surviving spouse, but no descendants and no parents. So this is what the diagram would look like. I cross out the letters to keep track of who is alive and who is dead. So if somebody is deceased, then they get X'd out. So in the scenario where the decedent only has a surviving spouse and has no issue and no parents, then the decedent's surviving spouse takes all. All of the property goes to the surviving spouse. Pretty simple. Now let's look at the second scenario. In the second scenario, the decedent has a surviving spouse and has issue, right? They have issue. Now, whether or not the surviving spouse has to share the estate with the issue depends on the circumstances. If all of the issue are also the surviving spouse's kids, and there are no other children outside of the marriage, no stepchildren, then all of these assets go to S, to the surviving spouse. So if we diagram that out, that would be the following scenario. Say there are 3 children, A, B, and C. The 3 children are all the product of this marriage, and there are no children outside of the marriage. when the decedent dies, the surviving spouse would get all of the decedent's assets. Now, let's say in addition to A, B, and C, S also has a child from a previous marriage. So previously, S was married to Q, and from that marriage, they had E. Okay. If S has children outside of the marriage, then that means S does not get all of the probate property. Instead, S would get $225,000 plus half of the remaining assets. The other half would go to D's issue, which would be A, B, and C. So this half would be split equally between these three. Let's change this scenario a bit. Let's say that the decedent has a surviving spouse and the decedent has descendants, but the descendants are not all from the surviving spouse. So the decedent has children outside of the marriage. Maybe previously the decedent was married to Z and had children over here, and these children N, Y, and M, right? So there's children outside of the marriage. Even if D and S also have a child, that would change the amount of money that S gets. In this case, S would only get $150,000 plus half of the remaining estate assets. That other half would go to the decedent's issue, which would be N, Y, M, and Q. Their issue because down the line we go. And that explains all of the scenarios that are in the second row over here. Okay, so let's look at this third row. Let's say that there is a surviving spouse. There are no issue, but there are parents. Maybe one or two parents, right? In that case, the surviving spouse would only get $300,000 plus 3/4 of the estate that is left after you subtract the 300. The remaining quarter goes to the parents. Okay, we're going to stop here and take a deep dive into what we do if there is no surviving spouse, but there are issues. We can note here the UPC rule says that all the issue would take per capita at each generation. We're going to talk a little bit now about what that means. So how do we calculate shares? And what do I mean by that? Well, if there is no surviving spouse, okay, let's say D was married to A. A predeceased or died before D, but not before they had 3 children, Q, Z, and M. So there is no surviving spouse. That means that once D passes away, it will be his issue that take. So here, D has 3 issue, Q, Z, and M. Well, how do we divide the estate amongst the 3 of them? Well, they are going to take equal shares. And that's pretty easy to do when we're dealing with a scenario where Q, Z, and M are all alive. Because in that case, each child would receive a third. Now, it gets a little bit more complicated when the children have children and when some of the children predecease the decedent. Generally speaking, if a child, or any other issue for that matter, predeceases the decedent, then the issue of that child will take in their place. Let me give you an illustration of what I mean. See, a decedent dies without a surviving spouse, but leaves 2 children, B and C, and 3 grandchildren, T, V, and K. As you can see, D's child, A, has predeceased them. How would we divide up or calculate the shares? Well, there are 3 ways we can calculate the shares. The first is using the Perstirpies Method. Second is using the per capita with representation. And the third is by using per capita at each generation. Let's go through each one of them. If we use the Perstirpies method, we first divide at the first generation of the decedent's issue. So that would be the children. So we divide at the children. Doesn't matter if the children are alive or not, they each take an equal share. So that would mean we would divide first here. If one of the decedent's children predeceases them, then we drop that share to the to that child's surviving issue. So we drop that share to that child's surviving issue. Okay, so here we have a predeceased child. So we're going to drop this share down to the issue of that predeceased child. And we split it equally amongst them. So T gets half, right? Because half of a third is a sixth. And V gets half. That would be a sixth. So if we applied Perstirpies, B would get 1/3, C would get 1/3, T would get 1/6, and V would get 1/6. Now note, K doesn't get anything. K doesn't get anything because K's parent, B, is still alive. Let's compare that with per capita with representation. All right, if we use per capita with representation, then we divide at the first generation where there is a live taker. In this case, that's still the children, so we'd still divide here. That means we would again get a third, a third, and a third. Then we continue on down. And the results in this case are going to be the same as with Perstirpies, right? Because if one of the decedent's children predeceases them, which A has, then that share gets dropped down and split amongst the issue of the predeceased child. So again, here we have 1/6 and 1/6, and lo and behold, it's the same answer. B gets a third, C gets a third, and T and V each get a sixth. So when would the answers for Perstirpies versus per capita with representation be different? It would be different if there is an entire generation that has predeceased the decedent. So if, for example, A, B, and C all predecease the decedent, then the answers for Perstirpies and per capita would be different. The reason is because for Perstirpies, we would divide at the first generation after the decedent, so the decedent's children. But for per capita with representation, we would divide at the generation with the first living takers. So instead, TV, K would get a third with per capita with representation, whereas with Perstirpies, we would have divided up here, and then, oh wait, if C has died, then what happens? Well, it complicates everything because we got to put C's share back here, so really it would be half and half. And then this would drop down, and this would drop down, and so the half would be split amongst T and V, so T would get a quarter, V would get a quarter, and then K would get half. So that's with Perstirpies. The next video will cover per capita at each generation.